All right. Hi, everyone. I think we're going to get started. My name's Louise Gibbons. I'm a partner at Oric in the Energy and Infrastructure Group in San Francisco. We are delighted today to have Clee and friends join us to talk about understanding recent developments in climate risk disclosure. So with that, I'm going to introduce Louise Bedsworth to introduce the rest of our panelists and get things started. Thank you all.
Great. Well, thank you, everyone. Really nice to see people here in person and online. Really appreciate you joining us for today's Lunch and Learn. My name is Louise Bedsworth. I'm Executive Director of the Center for Law, Energy, Environment, or CLE. We're a research center within the law school that really works to connect the expertise of Berkeley Law and the broader campus to policymakers, businesses, and other stakeholders with a real focus on how we advance pragmatic solutions to our most pressing energy and environmental problems. Through our Lunch and Learn series, we like to host conversations around recent research findings and activities that we have going on at CLE or across campus, but also to dive in on pressing and current issues, which is what we'll be doing today. So in today's topic, we're going to look at recent developments in climate risk disclosure, and we have a wonderful panel here to help us do that, who will really help us look at this from the domestic, sort of in-state California perspective and domestic perspective, international perspective, and then really how is this playing out with companies and businesses on the ground. So what I'll do is I will introduce each of our panelists, then we'll turn to them to give some opening remarks, sort of 7 to 10 minutes, and sort of their perspective on what's going on out in the world. And then we'll open it up for questions, and I have some, but we really hope that others will join in. So for folks who are online, please put your questions in the Q&A function on Zoom, and we will be going through those as well as getting questions from folks in the room. So really thrilled with the folks we have joining us today. First, we have Dave Jones. Dave is Director of the Climate Risk Initiative at CLE and a former Senior Fellow at the Climate Works Foundation. But prior to that, he served 2 terms as California's Insurance Commissioner, where he led the Department of Insurance and was responsible for regulating the largest insurance market in the United States, where insurers collect $310 billion a year in premiums and have a $5.5 trillion in assets under management. Dave led the department's response to California's increasingly frequent and deadly and destructive wildfires, including the 2015 Butte and Valley fires, the 2017 North Bay and Thomas fires, and the 2018 Mendocino, Carr, Woolsey, and Camp fires. He's a national leader and expert on climate risk and insurance regulation. And from 2011 to 2018, Dave led the implementation of the National Association of Insurance Commissioners Climate Risk Disclosure Survey. And then in 2016, he launched the Climate Risk Carbon Initiative, requiring insurers to disclose publicly their investments in coal, gas, and coal, oil, and gas utilities. Our next panelist will be Katie Hewlett. Katie is the Director of Outreach and Global Investors at the IFRS Foundation. She leads the ISSB Investor Advisory Group, comprising over 60 leading global asset owners and managers, supporting a global baseline standard for the communication of corporate performance on sustainability-related risks and opportunities relevant to investors. This reprises similar roles Katie has played at the Value Reporting Foundation prior to its merger with IFRS in August of 2022, and at the Sustainability Accounting Standards Board. She is also a bear with a degree in Japanese from the University of California at Berkeley, and she worked for the investment bank Salomon Brothers for over a decade in the US, Japan, and Hong Kong. And then finally, JT Ho will be speaking as well, and he is the head of Oric's Public Company Advisory Practice. He advises public companies and their boards on corporate governance, securities reporting, shareholder activism, executive compensation, and sustainability matters. He counsels companies on board and committee oversight, assessment, independence, and composition issues, and helps companies develop effective stakeholder engagement programs and governance-related disclosures. On the securities front, he focuses on advising clients in the connection with securities offerings, proxy statements, periodic SEC reports, stock exchange listing obligations, stock repurchases, and the sale and reporting of securities by insiders. So I'm very busy. JT.
You can kind of stop.
Yeah. Yeah. But yeah, more recently, he's helped companies navigate ESG-focused proposals and activism issues and the growing anti-ESG movement. So with that, I would like to turn it over to Dave to kick us off, and then we'll go to Katie and then wrap up with JT. Thanks.
Terrific. Thanks, Louise. And thanks to ORIC for hosting us. It's a great treat to be here with you talking about what is a critically important and very timely issue, and that is developments around disclosures that real economy and financial institutions are required to do or can do on a voluntary basis, both to report the risks they face from climate change, as well as the contribution they may be making to climate change. So just a little bit of background. In about 2015, the Financial Stability Board of the G20, which was the board that was put together after the 2007-2008 financial crisis to make sure that didn't happen again, they took up the issue of climate change and the risks that climate change might pose to financial institutions, insurance companies, banks, mortgage lenders, and others, as well as the risks that it might pose to the global financial system and to national financial systems. And to begin addressing that, the Financial Stability Board, made up by the ministers of the Departments of Treasury of the largest 20 economies in the globe, decided that a task force on climate-related financial disclosure should be established, populated by real economy leaders as well as corporate leaders, chaired in this case by Mike Bloomberg, and that it was tasked with coming up with a framework for disclosure with regard to climate-related financial risks that companies and financial institutions might face. In 2017, that task force, also referred to as TCFD, you'll hear a lot of abbreviations and acronyms in this presentation because there's a lot of them, came up with a framework for disclosure. The first comprehensive look at the impacts that climate change might pose to the U.S. financial system was done in a report commissioned by the Commodities Future Trading Commission called Managing Climate Risk in the United States Financial System. It looked across all aspects of the U.S. financial system and all federal and state financial regulators and reached the conclusion that climate change actually does pose a systemic risk to the United States and global financial systems. And then the Biden administration in 2021, President Biden issued an executive order directing an all-of-government approach to begin addressing the impacts and the risks associated with climate change. So essentially, there are commonly understood to be two major categories of financial-related risks that climate change poses. First are the physical impacts of climate change, things like we're experiencing, sadly, in real time here in the United States: extreme heat, wildfires, flooding, tornadoes, severe convective storms, hurricanes, pick your peril, right? Those things are not only killing people, injuring people, destroying property, but they also are impacting financial institutions that are either making loans to homeowners or loans to private businesses or insurance companies writing insurance. The physical impacts of climate change are impacting real economy corporations as well as the financial institutions behind them. So that's essentially the physical risk associated with climate change. Then there's what's called transition risk. And as we transition from an economy that is a major emitter of greenhouse gases to an economy that does a lot less of that, and that transition is being driven by technology, by market forces, by policy, and other aspects of this transition, that transition poses risk to financial institutions too. So say you're a bank and you're lending heavily into the fossil fuel industry, say you're lending heavily into coal. The loans you make to the coal industry might face some risk to the extent that we're going to transition away from coal. Or say you're a big investor, like a pension fund or any other institutional investor, and you're investing in fossil fuels. As we transition away from fossil fuels, the value of those assets may decline over time, and that poses a transition risk then to your balance sheet. So I'm going to talk a little bit about two laws that California enacted, and then touch briefly on the SEC rule that I believe my colleague JT is going to go into a deeper dive on. But importantly, there were two major laws enacted by California last year that deal with climate risk disclosure. The first of those, which is Senate Bill 261 by State Senator Stern, which is the Climate-Related Financial Risk Act, is about requiring companies and financial institutions to report the risks that climate change poses to them as economic enterprises. So just a little history here and a point of pride for our center. In 2020, we issued a report that was funded by the United Nations Principles for Responsible Investment, where we did a sustainable or roadmap for California, the sorts of things California might do to try to encourage more responsible investment. And one of our seminal recommendations was California ought to adopt a law that requires companies and financial institutions to report the climate change-driven financial risks they face using the TCFD framework. See, I promised you an abbreviation. So we actually drafted that bill, what later became Senate Bill 261 in 2021. Senator Henry Stern picked up the bill, ultimately saw it through in 2023. Essentially what that does is, first, it requires companies and financial institutions to use this TCFD framework that I referred to a moment ago to report the risks that they face from climate change. That requires them to talk about their governance associated with dealing with those risks, their strategies, their metrics, their targets. It applies to both public and private companies. Importantly, there's a revenue threshold. These companies, for it to apply, have to make more than $500 million a year annually. About 10,000 companies are covered by this new California law. And most importantly, it reaches not just companies that are headquartered in California or incorporated here, but any company doing business in California that reaches that revenue threshold is covered by this law. So in effect, we've established a national standard for climate risk disclosure and reporting by virtue of enacting a California law. There is an important point. There is a materiality precondition that's a part of this framework, and that is these risks have to be material from a financial standpoint in order to be required to be reported, although companies are allowed to go beyond just reporting material risks. And timing, biannual reporting starts January 1st, 2026. The second law that was enacted in California just this last year is Senate Bill 253 from Senator Scott Wiener, the Climate Corporate Accountability Act. This is a law that requires companies and financial institutions to report their emissions, their greenhouse gas emissions. Scope 1 and Scope 2 emissions, that is, direct and indirect emissions have to be reported by 2026. Scope 3, which is the supply chain, up and down supply chain emissions, have to be reported in 2027. Also importantly, applies to both public and private companies. The threshold is different. It's those making more than $1 billion a year in annual revenues. That's only 5,000 companies, basically the 5,000 largest companies in the United States. Again, it's a national standard by virtue of the fact that it applies to any company that meets that threshold, which is doing business in California. And very importantly, no materiality precondition. So companies and financial institutions are required to report their Scope 1, Scope 2, and Scope 3 emissions, regardless of whether they determine that those are material from a financial standpoint. I think JT is going to do a deeper dive on the SEC climate risk disclosure rule that was enacted this year. Critically important, applies to publicly traded companies, different deadlines for small and large companies, but only requires Scope 1 and Scope 2 emissions reporting if it's material, no Scope 3 requirement. It does not refer specifically to the TCFD disclosure framework, but basically adopts that framework in the rule so that essentially companies will also be reporting things like governance strategy, risk management targets. I'll leave to JT to go more deeply. Challenges to implementation. First of all, a lot of lawsuits have been filed to challenge these two sets of rules, the California laws and the SEC rule. Federal lawsuits have been filed against the SEC climate risk rule. 11 states have joined together to file a lawsuit, energy companies, individuals. The SEC decided to voluntarily stay implementation of its rule pending the litigation. And then the California and U.S. Chamber and others have sued to challenge Senate Bill 253 and 261. And we could talk a little bit more about those challenges. In addition, another challenge to implementation is that our governor, who signed these two California bills with great fanfare and announced he was going to do so at New York Climate Week last year, in his proposed budget earlier this year, he neglected to include funding for the regulatory agencies to promulgate the regulations to implement those laws. That didn't sit terribly well with the legislators and others, and so they prevailed upon the governor in his May revision of the budget, which is a standard part of the California budget practice, to put money back in the budget to cover implementation of these two laws. And so the adopted budget in June 2024 funded the regulations. And so CARB, which is the regulatory agency that's tasked with implementing these two new California laws, is now funded to do it. However, the saga hasn't ended there. Just 2.5 weeks ago, the governor's Department of Finance surfaced what's called budget trailer bill language. So what happens is the budget gets enacted in June, but typically there's a bunch of laws that have to be changed to conform the laws to the budget. And so when the legislature comes back in August, they take up all these bills. They're called budget trailer bills because they trail behind the budget. And so the Department of Finance has suggested, and the Newsom administration has suggested, some language that would actually delay the implementation of the two newly enacted California laws by 2 years. The authors vehemently opposed that. They issued a statement saying that was not a part of the budget deal that the legislature entered in with the governor. Climate groups, corporates, and investors are also opposing the delay. Stay tuned. August is going to be a very interesting month to see whether, in fact, we will actually move forward smartly with requiring climate risk disclosure or delay it by 2 years. Now, another point I want to make is that in the United States, and even in California, we are lagging significantly behind the EU and Asian regulators who have been moving smartly with regard to climate risk disclosure, climate risk stress testing, which is tests that are done against the balance sheets of financial institutions to see how they withstand various climate change scenarios, and also what are called net zero transition plans, plans that get adopted by a company or financial institution to explain how they're going to get to net zero in terms of their own emissions. One challenge of our being behind and having a different set of requirements, or in many cases no requirements, than the EU and the Asian regulators, is that it's going to pose challenges for U.S. corporates and U.S. financial institutions in terms of different requirements in different jurisdictions. So one is, and I'm sure Katie or JT will talk more about this, but the EU, which has adopted its own set of reporting requirements under the Corporate Sustainability Reporting Directive, CSRD, another important abbreviation, or the Corporate Due Diligence Directive, CDDD. Well, they have a double materiality standard so that you have to report not only if the risk is material to you as an enterprise, but you also have to report if you're doing something that actually causes a challenge to the environment or the economy. The good news is there's still a lot of voluntary climate risk disclosure going on in the US. The SEC, as a part of its rulemaking, reported that 60% of the Russell 3000 companies in the US and 90% of the Russell 1000 companies are providing some form of climate-related information already. And nearly 60% of the Russell 1000 companies are already disclosing scope 1, scope 2. So the California laws and the SEC laws are really an attempt to try to codify what's happening on a voluntary basis, but also bring some standardization and uniformity across markets so that you don't have competitive disadvantage for those that are choosing to voluntarily report versus those that are not. And then another important point is that investors really want disclosure as a part of their due diligence and decision-making. I'm sure Katie will talk more about that. So that's it. That was a rocket docket, wasn't it? A quick tour through, but thanks for your kind attention, and really excited to engage with my colleagues and you as the audience on this issue.
Thanks, Dave. And we'll turn now to Katie. And I just want to remind folks to please, if you have questions, especially online, drop them in the Q&A.
Thanks very much. So I'm Katie Schmitz-Hewlett, and I do lead investor outreach for the IFRS Foundation on the sustainability side of the house. You might have heard of the IFRS Foundation if you've heard of the International Accounting Standards Board, which has given us international accounting standards for financial reports, and they now have a sister board, the International Sustainability Standards Board, where I am now working by way of 2 mergers over the pandemic, which I don't recommend doing. But I do recommend, if there's one thing that you take away from this today, hopefully it's that this alphabet soup and the acronyms that Dave started talking about is starting to kind of converge down into a nice consommé, something a little less chunky and a little more tasty. So through those mergers that I mentioned, we have really started to rationalize investor-focused standards and frameworks. So Dave talked a little bit about the TCFD with the advent of ISSB's standards for not only climate disclosure, but also broadly speaking, sustainability disclosure. The FSB recognized the culmination of the Task Force on Climate-Related Financial Disclosures work, or the TCFD's work, because TCFD is at the core of IFRS sustainability standards. And I'll talk a little bit more about that in a minute. So this TCFD recommendations still live, but we've taken those recommendations and we've augmented them in the ISSB standards. And I can tell you more about that. But we also have under our umbrella now, the Climate Disclosure Standards Board, the SASB standards, which are also a core part of the IFRS standards for sustainability reporting, as well as the International Integrated Reporting Framework. So all of those investor-focused standards and frameworks are now under one roof and are now a key part of ISSB standards. Why do we exist? It's to create a foundational global baseline for the disclosure of information related to sustainability-related risks and opportunities for investors. And all of what Dave talked about, or much of what Dave talked about, is, we are aware of the changes that are happening in our environment, not, the least of which is climate change, and investors are critically aware of this and are seeking better information upon which they can evaluate the risks and opportunities in their portfolios. They have global portfolios and they need a global standard that they can use to compare companies around the world with one another. So ISSB is meant to be a foundational baseline that jurisdictions can add building blocks on top of. If there are specific things in their jurisdictions, for example, in Canada, in Australia, there's legislation that requires the consideration of First Nations concerns and issues that you would add on to the ISSB standard. So right now, or just recently, the Canadian Sustainability Standards Board, which is Canada's body that is considering the uptake of ISSB standards, needs to take into consideration and add a supplemental building block that covers Indigenous rights on top of our standards. So the idea is you have this baseline, you add on to it, you don't dent it. So keep that in the back of your mind. Sorry, a little fast here. So jurisdictions around the world are taking steps to adopt the ISSB standard. So there are more than 20 jurisdictions around the world that are on a path to this adoption. It takes place and sort of plays out on different timelines, different modalities around the world, but it represents roughly 55% of global GDP of the jurisdictions that are on this path. 40% of global market cap. The asterisk there is to remind me to let you know that we don't include the US, which is the largest capital market in the world, in the statistic, because the SEC is never going to point to ISSB standards and say, use that. But what they can do, and I'll talk a little bit more about later, is they can cite ISSB standards as a useful tool to comply with SEC requirements. So we can talk a little bit more about that later. And then jurisdictions representing more than 50% of greenhouse gas emissions are on this journey for adopting the standards. And here is what that looks like, sort of region by region. And you see the largest component in Asia, Oceania. And in the context of talking about Europe and the CSRD that Dave talked about, and those reporting requirements that many US companies will get scoped into, we see many, many jurisdictions in Asia, Oceania who are not adopting an ESRS or a CSRD type approach. And that's really important to think of. And it's interesting if you threw California onto this list, right? It's larger than many of the economies that are on this list. So because TCFD is a core component of ISSB climate disclosures, it is significant that the California bills that point to TCFD, now TCFD is in our standards. The momentum is pretty significant for the uptake of our standards. That said, the European Commission did have a head start when it came to the promulgation of their standards, their CSRD standards, because I won't give you the history of all of it. We are today where we are today, but there were pieces of legislation in Europe that sort of kicked the domino over so that the EFRAG, which is the European standard setter that has put forth the European Sustainability Reporting Standards, or the ESRS, got to work before the ISSB was even formed through our mergers that I mentioned earlier. That said, investors have really were the wind in the sails of the IFRS Foundation establishing the ISSB, because investors over the years really started to rally around the SASB standards and the TCFD framework for the way that they wanted to receive information about these risks and opportunities in their portfolios. So the ISSB's very existence is because investors wanted to see disclosure like this. And so it is, I think, very important to note that investors, even in jurisdictions where there is not going to be a requirement for ISSB-based disclosure, investors are going to continue to ask for it through updates to their proxy voting guidelines. I think I may not have that in this deck, but we're going to continue to hear investors ask for this information and ask for the word here, interoperability. So if you're reporting to European standards, do it in a way that uses the same language that ISSB is using. And we've done a lot of work on that, not the least of which is this guidance on interoperability that shows how IFRS sustainability standards and FRAG standards really can be used by preparers, gives them support, shows them how they can align their disclosure, talks about the different types of materiality assessments, how the information should be presented, where it should be disclosed, the types of analysis that they can be conducting as they're particularly disclosing on their climate risks, and explains why companies still need to use both sets of standards, but how they can do so in an easier way that makes it more cost effective for them to do it, and in a way that helps communicate with investors. I know you're going to talk a little bit more about this, but the US SEC sits on the ISSB's jurisdictional working group, as does IOSCO, the International Organization of Securities Commissions. And we did that very intentionally to help ensure that we were working on this path to interoperability and that we weren't veering off in one direction or another. So when we put our climate standards together, the SEC was very aware of what we were doing. And the earliest version of the SEC's climate rule was very aligned with our climate disclosure rule, IFRS S2. You can see here, there was a high level of alignment in addition to the Russell 1000 companies that Dave mentioned. 78% of Russell 1000 companies were already disclosing to SASB standards, and 50% were aligned with TCFD recommendations when we first looked at the SEC climate rule. So although, as I mentioned, there won't be a requirement for US companies to disclose using ISSB, the SEC climate rule in a footnote does say, yeah, we're not pointing to ISSB right now because we don't see where jurisdictions are on the path to adoption, but they kind of left the door open that they might be able to give it a nod at some point in the future. So that's what we're hopeful for. But at the very least, we know that investors are going to continue to ask for this information. We see BlackRock and Vanguard, two of the largest index fund managers, having updated their global proxy voting guidelines, asking for ISSB disclosures. We've seen the Global Asset Owner Forum, which has members including Norges Bank Investment Management and GPIF, two of the largest pension funds and sovereign wealth funds in the world, seeking companies to voluntarily use ISSB disclosures, as well as asking jurisdictions to adopt them to the fullest extent that they can when they take them up in their adoption of standards around the world. So there's tremendous investor support for this kind of disclosure, and we expect to see more of that. And I think that's my last slide. So off to you.
Thank you. And I'm not going to repeat a lot of what's already been talked here. I think what I'm going to focus on a little bit more is the history of the SEC rule and where we are today and what companies ought to do from a value creation perspective. So my slides, well, they may not be uploaded, but I don't really need them. So what we can do here is just kind of get back into the history of the current climate rule. So there are existing SEC climate rules even before this that go back to 2010, and they're principle-based. They're couched in the principle materiality. Companies are required to disclose climate risks to the extent that they're material. They have to talk about climate with respect to their business to the extent that's material. If climate-related factors are influencing financial events in a material way, they need to be disclosed. That's what's under the existing guidance. After that, in 2021, we had a climate sample climate comment letter from the SEC that actually took this 2010 guidance and elaborated more on the sort of examples of what they expect to see from companies. It was very much a precursor to what we had with the proposed climate rules. But the proposed climate rules, in turn, took that a bit further. And we went from materiality to a prescriptive-based approach, irrespective of materiality, for a number of different things, including Scope 1 and Scope 2 emissions. And it also introduced the requirement to have board expertise in climate either being disclosed, whether you have it or not, and certain financial reporting measures, which was in the back of the various SEC filings that required a lot of work. And there's but some potential audit issues related to that. Well, then you fast forward to what the final climate rule looked like. And now we have materiality being reintroduced in a number of key areas. You're supposed to disclose material climate related risks. You're supposed to disclose the board's management of climate risk generally, irrespective of materiality, but how management oversees material risk. So you see materiality introduced there. We also see materiality being introduced in terms of targets. In the proposed rules, you had disclosed your climate related targets, irrespective of materiality. And all that was an attempt to try and make these rules more palatable to survive judicial scrutiny. The reality, unfortunately, is you still have judicial scrutiny irrespective of these things. The rules are being suspended right now by the SEC, and all the various lawsuits are consolidated and being heard right now by the Eighth Circuit. The Eighth Circuit is made up of judges, all of whom have been appointed by a Republican president, but for one. And so you may ask yourself, well, what's going to happen to this rule right now? I think it could potentially survive, but if it does survive, there could be a lot of changes, or it's ultimately struck down altogether. So what has this led companies to ultimately do? Our panelists have identified other SOR regimes that are still present. We have California, which I think, at least based on the public affairs folks I've talked to, has a far greater chance of surviving, despite the fact that it is also subject to judicial challenge. And then we also have Europe with the CSRD, which climate is one of the important topics. Then we have the CSDDD, in which one of the requirements is to adopt certain initiatives related to 1.5 degrees Celsius climate reduction. So we have all these other things in place right now, irrespective of what happens to the climate rule. I think it's also important to remember that even if the climate rule ultimately dies, we also have this 2010 guidance that I go back to in the very beginning of my remarks, which talks about the need to disclose material climate related risks and material climate related impact. And what I've always recommended companies to ultimately do is, read the room in some ways. Clearly, climate risk can be material to companies. It's certainly something investors care about. There's a desire for uniformity among climate standards. So in light of that, let's make sure climate risk is being considered in your existing risk management process, and that when you're doing it with your existing risk management process, think about some of the factors that are actually material in determining risk. What are the impacts of this on your consumers, your employees, your other stakeholders? How does this factor into your business strategy? Look at this in a very robust way that addresses the very things that have been contemplated by the TCFD and other sort of voluntary reporting regimes regarding risk, and make sure all that filters into your decision as to whether or not climate risk is material. Now, to the extent climate risk is material, that means that companies should try to manage that risk. And further, that also means that that risk should be elevated at some level to the board. It could be through a board committee or whatnot. There's got to be an information reporting system that goes up the proper channels, again, to the extent risks are material. If they're not, fine. It ends up staying at the initial ERM process, but you at least have to go through that exercise. You have to do it in a thoughtful way. The other thing that I think is really important in all this is to also make sure that management and the board have sufficient education in this process. I think climate risk is one of the hardest things to understand. There's a lot of taxonomy. We talked about physical risk. We talked about transition risk. At the very basic level with the board, they should at least understand what those concepts are, even if it's the case that those risks aren't material to companies. And at the management level, your ERM program should be such that you have sufficient expertise and personnel at the management level that the right people are actually looking at it. Our old days of having a siloed group doing CSR, which is precursor to ESG, and looking at these things and none of that getting elevated to ERM, those days are long gone. It doesn't work no matter what our reporting regime is. We just have to move forward and advance that. The other thing I always encourage companies to do is look at what your peers are doing. We have a lot of good voluntary disclosure to see whether or not companies are lagging what they're doing. We haven't talked so far about the CDP reporting. That's a great resource for companies to look to see what other companies are doing potentially and making sure that their climate practices are consistent with peers. I will say this, having seen this in the activist context, the extent that you are lagging your peers with regard to both disclosures as well as mitigation practices, you could be subject to scrutiny from shareholders who take these issues very seriously. And finally, the last thing I'd say, this is probably the most important thing, is we are living in an environment now where there are a lot of anti-ESG and anti-climate initiatives going out there. There's a lot of noise in the room. Ultimately, what companies need to do is whatever they think is accretive to long-term value creation. And they should focus both in terms of reporting and their actual practices on what gets them there. And that's the most important thing. Because ultimately that is what will make both your reporting and your practices defensible in the eyes of the vast majority of your stakeholders. I'm done with my remarks. Thank you.
Great. Thank you all so much. That was really helpful. We want to open it up for Q&A, but so maybe I'll kick it off and give folks an opportunity in the room and online to pose some questions. I guess, JT, you sort of touched on this towards the end. Dave, you raised this with what's happening in California right now. I wonder if you all could speak a little bit more about sort of how durable these laws are, whether we're looking at shifts in government, which we certainly have been seeing both potentially here in the United States, but in Europe as well. And with some of the recent Supreme Court decisions that we've seen in the United States, what that could mean for these kinds of rules.
You want to start? I may give it that task.
Yeah.
Yeah, I would say this. I think I've already covered a bit with the state of the SEC climate rule. We already have all the various oral arguments and hearings scheduled in the fall. I certainly think it's a wait and see approach. You know, when I speak to the auditors about this, at least for that rule and what companies should do, they always take a very conservative approach and say, hey, look, we still have a rule. It's not suspended yet. We ought to do things and this and that. I'm of the view that you should be doing a lot of this stuff anyway, or at least, as I mentioned earlier, ascertaining whether or not risks are material and making sure that all this is being properly incorporated in both your risk management and also to some extent your business strategy too. So that's my perspective on it. Again, these opinions are only my own, but the extent that you should at least be thinking about what you need to do and whether this makes sense now, irrespective of whether you have a rule or not. Because again, we have California and we have these other regimes. So do you want to go next, Dave?
I'll go next. So, as JT said, one of the challenges with regard to the SEC rule is the cases have been consolidated in the 8th Circuit. That's a terrible circuit. And then above the 8th Circuit, you have the Supreme Court, which has shown no lack of appetite for striking down all manner of prior precedent related to the administrative state and administrative interpretations of statutes. So it's a challenging environment for the SEC rule. And I think, look, there were 24,000 comment letters. It took 2 years. The SEC was very, very careful. And as JT said, the first version of the rule was much more robust. The final version of the rule, as JT pointed out, throughout is populated with tying requirements to materiality determinations. So I think it's a well-grounded rule. I think it's well within the authority of the SEC under its enabling statute and successor statutes, but it's a challenging judiciary given the philosophies of the Supreme Court and members of the 8th Circuit. I agree with JT. I think that the California laws have a much higher prospect of surviving. we're already seeing the AG here mount enabled defense. I mean, this first line defense is, look, I mean, we haven't even done the regulations yet, so this seems a little bit unripe to take this on now. I think that those two laws have a far better prospect of surviving. But even worst case scenario, and both sets of laws, the two California laws and the SEC rule go down, I also agree that there's a voluntary disclosure that's occurring with greater frequency and greater broadness across both corporates and financial institutions. And it's being driven by demands from investors, institutional investors, the major public pension funds in states are asking for this kind of disclosure. Other financial institutions, shareholders are asking for it as well. And so I think we're going to see, notwithstanding what happens vis-a-vis these two sets of rules or laws, that there'll be a continued expansion of voluntary disclosure. And what's helping to drive that is the work that Katie and her colleagues are doing to try to consolidate the various prior accounting and reporting regimes and bring them into closer alignment. I think the other driver with regard to voluntary reporting in the US is that this train has left the station in terms of Europe and Asia. And there are many US corporates and many US financial institutions that have substantial business activity in Asia and Oceania, in Europe, and they're going to be required to report. And so I think that that's going to continue to drive more voluntary reporting. So I think there's a lot of durability, if for no reason then to make rational investment decisions, you need this information to better decide, as well as the corporates and financial institutions themselves making business decisions need to collect this information to make better decisions with regard to adding value and improving returns for their investors and owners.
Yeah, you did remind me of something. There actually is another California law that's in place, AB 1305 on greenwashing. That one is subject to much less scrutiny from both sides. It actually has some bipartisan support. What this is basically ensuring that companies are making substantiated claims regarding climate initiatives. And I think a lot of folks from both sides do not like greenwashing. It is certainly something that I think is problematic from the consumer end and has a lot of corollaries from the investor end too. In fact, if you think about it, one of the goals here with respect to the greenwashing stuff is to ensure that companies are not misleading consumers, which in turn is kind of critical to actually having this sort of long-term value creation from a consumer perspective, and which is also very important from shareholders. The other thing I think that's important to talk about, so that one is probably going to be fine, so we didn't talk about that, is the consumer desire for a lot of this. When a lot of companies I work with have European customers, and irrespective of the rules and so forth, they are also demanding targets, and they're also demanding reporting things in line with the ISSB and other sorts of standards like that. So consumers drive business, and they are going to continue, particularly European ones, are going to continue to demand reporting, and that companies in some cases adopt targets and things like that. So I don't think I see an end to it anytime soon from that perspective as well.
I couldn't agree more. And even without the climate guidance in 2010, we still have Reg SK. And although I'm not an attorney, I hang out with them a lot. And I wrote SASB's comment letter to the SEC on the Reg SK consultation long ago. Basically says what IFRS S1 says. If it's material, you should be disclosing it to your investors. It's pretty basic. And to your point about reading the room, this is about good management. Investors really don't want disclosure for the sake of having disclosure. They want disclosure to see how companies are managing risks and opportunities, and whether or not they've got their eye on the ball or not, and whether or not they're listening to consumer demands or their own employees' demands for how they're going to attract and retain employees for a company, regardless of the industry that you're in, if you've got it right. And so train has left the station. Whether these rules endure in the legal framework or not, there's tremendous demand for it. And I don't think it's going anywhere.
Great, thank you. I want to give an opportunity for others to ask questions. Is there anyone in the room who has a question? I can keep asking them. Oh, we have one.
Hi, y'all. So I'm trying to understand the fiduciary relationship of an officer or director of a corporate entity with respect to these voluntary disclosures. So whether what y'all said or what implied what y'all said, these directors and officers would have an obligation to disclose various emissions to their shareholders. On the other hand, if you're a traditional fossil fuel company, you could argue I have a fiduciary obligation not to do a voluntary disclosure. It costs a lot of money. It impliedly increases the cost of production. It could be an admission of liability. And so how have courts analyzed, or have they analyzed potentially these competing fiduciary obligations on behalf of directors and officers to the public with respect to voluntary emissions?
I could try to take that. So I only can speak from the Delaware perspective, but directors have a duty of disclosure. And the duty of disclosure is affected through management ensuring that things that are material investor are properly disclosed through the usual channels. So I don't know if that's helpful or not. I mean, if someone, I'm going to tell you now, if you're one of the major 100 emitters and you're not talking about climate in your SEC filings, you're going to get into trouble in a number of different ways. I think that you can certainly draw comments from the SEC under the existing regime. And I also think you're going to get a huge push from investors for failing to disclose material risks. And there could also be some private rights of action related to that as well. Okay.
You covered it.
Great. Any others? So maybe I'll ask you guys a question then, which you touched on this a little bit and maybe relates a bit to thinking about the durability, but could you speak to the backlash on ESG right now and kind of what that is doing in this space overall? And do you see that something that we're going to continue to battle going forward, or is it sort of a fleeting political moment?
You want to start?
Sure, I'll start. So I'm reminded that in 2015, when I was insurance commissioner, I required the 1,300 licensed insurance companies doing business in California to begin publicly disclosing their investments in coal, oil, gas, and utilities that derive more than 50% of their electricity from coal, oil, and gas. And I did that not because I'm an environmentalist, I am, but because as a financial regulator, those classes of assets, fossil fuels, face the greatest potential loss of value as we transition away from a fossil fuel-based economy. And part of my job, maybe the most important part, was making sure that insurance companies are investing in ways that retain value so they have reserves available to pay claims. That's a big part of what it means to be an insurance commissioner, is focusing on financial solvency. I got a nice letter from 12 red states attorneys general and one governor threatening to sue me for simply asking these questions. I'm a lawyer. I wrote back a very thoughtful, learned response, I think, indicating the short version of it is that it would be insurance regulatory malpractice not to be asking these questions of companies, that it was well within my right to do so. These companies are all licensed in California, so as the insurance commissioner, I'm allowed to ask them relevant questions about their financial situation, at the end of which I said, but if you want to sue me, bring it on, literally. They didn't sue. Sadly, though, well, that may have been one of the first, it wasn't the last, threats of litigation by politicians in very conservative states where there's a lot of climate change denialism still going on. And that's manifested itself in states taking up and in some cases enacting bills that prohibit their state from considering environmental, social, or governance factors in state procurement, in state investment, in doing any kind of state business. These laws also, in some cases, sought to attach these requirements on their pension funds, et cetera, et cetera, et cetera. What's interesting is that the private sector has been leading the charge against many of these anti-ESG laws at the state level because these are risks that the private sector believes it needs to consider, at least not be barred from considering. So when Indiana took up a state law that would have prohibited all state chartered banks from considering environmental, social, and governance factors, the Banking Association rose up, descended on the Illinois legislature, it's Indiana legislature, this is a bad idea, and they backed off. Texas had a great idea. They introduced a bill that would prohibit insurance companies licensed in Texas from considering environmental risks. Oh, I don't know, things like wind, tornado, hurricanes, barrel, right? Now you can imagine the insurance industry response to that was like, that's nuts. And they succeeded in watering that bill down to it being almost nothing. So I think there's a lot of political currency in some places to advance these things. It's interesting that the private sector is pushing back. I also think that as a political talking point, it's begun to dissipate dramatically. We had a leading Republican presidential primary candidate, and that's all he wanted to talk about, and it got him nowhere. And the current candidate for president of the Republican Party is really not beating it as a drum any longer either. So I think as a political issue, it's kind of run its course too, but that's not to say that there doesn't continue to be these efforts in various states to try to enact these laws, which would ultimately be inimical to the economies in those states, the financial institutions in those states, the markets in those states. So those are my thoughts on that.
Yeah, I guess my thoughts are just from what I see, and we certainly have a number of private rights of action. Obviously, a lot of it, I know we're talking here about climate, but a lot of it's in the DEI space in particular. I would say that with respect to climate, we still see a lot of anti-ESG shareholder proposals. And just to give a little color, shareholder proposal is a proposal brought forth by a shareholder that meets certain requirements under SEC Rule 14A8. And these proposals, which are pretty short in nature, are included in the company's proxy statement and can be voted on by shareholders. Traditionally, these proposals have gotten very, very low support in the single digits, but we still see a lot of them. And I certainly see now some very unusual private rights of action. I've seen some, I won't name the company, but they were targeted for saying this creates long-term value and saying, well, how do you substantiate that? So I certainly think that the plaintiffs are being clever about this. We're still seeing a lot of it. And I don't expect to see that to dissipate anytime soon, at least based on the number of anti-ESG shareholder proposals and suits that we're seeing there. Again, I always think the best antidote against these criticisms is to focus on your business and do what promotes long-term value. That's the easiest way to address claims of corporate waste and some of these other considerations from these groups.
I'll add, and I can't agree more with what you've both just said, but I'll also add that I think it's going to help improve, it's going to help investors up their game on this and to get more precise about what it is they actually mean. And arguably, ESG was made a target of because some investors got a little sloppy and were slapping ESG labels onto funds that really hadn't changed from how they had been constructed originally. And now they had a new shiny label and they weren't necessarily doing what the tin said. So I think the term may go away. We'll see. We've seen some of investors shy away from using the terminology ESG, but what they're really talking about is, as one of our investor advisory group members says very eloquently, 21st century business risks and opportunities, things that weren't on the radar before, but that we now understand can affect value, and that they would be not living up to their own fiduciary duties were they not inquiring about them, if they weren't trying to incorporate them into the total mosaic of information that they're taking into consideration as they're making investment decisions, right? And so they're going to get more sophisticated about how they're asking for this information and about why they want it and what they're doing with it. But what you'll hear from all of them if you ask is, right now we're making business decisions, we're making investment decisions based on assumptions, based on estimates, because you're not disclosing this information. Wouldn't you rather have us make decisions based on what you actually know and are managing? And I think that's really where the gears connect, right? Is that, again, they're not asking for information to bother companies. It's investors' money. They want the companies to invest it well in the systems that are going to be helping ensure that the management of whatever the enterprise is on target to meet the risks and opportunities that they're presented with. So it's simply widening the lens of information that investors have wanted and needed to make investment decisions for decades.
Great. Well, we have about 3 minutes left. So I'm going to ask a question and ask you all just to answer in 1 minute. And it's maybe a step back from this. So as we look at these rules around climate risk disclosures, emissions information, at the end of the day, what we're trying to accomplish is significant reductions in greenhouse gas emissions and a massive transition of our energy economy. How do you all see these rules fitting into that overall strategy?
So, I mean, the estimates vary, but we need trillions of dollars of capital to flow into green as opposed to gray. But one example, alternative energy versus fossil fuels. And I believe that these disclosure regimes are critically important in and of themselves to better help real economy companies, financial institutions, investors understand the risks that are faced and respond accordingly. But I also think they're important from a systemic standpoint in order to arm financial regulators and financial policymakers with information necessary to understand what might be happening more broadly in a financial system and where the risks are and what the flow through channels are potentially. And then thirdly, I think it's important in terms of a reorientation of capital towards the kinds of investments and activities we need to transition to an economy that is producing less greenhouse gas emissions. So I think first and foremost, it's about the fiduciary responsibilities of corporates and financial institutions. It's also important from the standpoint of maintaining the viability of financial systems, but it's also important in terms of driving the transition we need vis-a-vis capital.
I'll just go out and say the SEC has said this many times, and I assume this is similar in California, that their rules are disclosure focused. They're not intended to actually drive change. That actually is not how it works out in practice. And so I just want to start first that these are not prescriptive rules in terms of actions, but just disclosures. That being said, I think where we are ultimately in terms of investment is that there is still a lot to be done, at least from my perspective, in terms of climate risk oversight and management. I'm a lawyer, I practice with companies. My view is that from a prescriptive perspective, that's the thing that I think needs the most evolution. I think it's getting there. I think there's a lot of different systems that are in place that are evolving, but that really needs to be done, putting aside any disclosures. And in the process of figuring out what material risks are from a climate perspective, I think there's also the potential for opportunities as well. And that's something that I think a lot of people don't really focus on as much. It's really a risk-focused perspective. But I think the more we actually better understand climate risk, we'll actually see a lot more opportunity as well.
Couldn't agree more. And I think, it's trillions of dollars of investment necessary to make this transition, but that includes the brown and the gray entities needing to turn less brown, less gray to more. So it's not we're going to flip a switch and immediately or 10 years or put it's going to be every part of the economy needing to make a transition of some kind, and investors wanting to understand, okay, how are you positioned to turn from whatever color you are into another color? What capital allocations are you making or not making? And should I be overweight, underweight? How should I think about your governance? Should we think about changing out the board if you don't have your eye on the ball? So it's this, you can't manage what is not measured. You've heard it time and time again, and that's really what peace disclosure plays in all of this, but it's not the only thing that needs to happen, right? It's just a part of the puzzle.
Great. Well, thank you so much, Katie and JT and Dave. This was really wonderful. Thank you so much to Oric for hosting us here today and for being a great partner to CLE. We really appreciate it. And thank you to everyone who joined us online and here in person.